Today, my topic is the Protection of Women from Domestic Violence Act 2005. Introduction. Domestic violence is undoubtedly a human rights issue and a serious deterrent to development. The Vienna Accord of 1994 and the Beijing Declaration and the Platform for Action 1995 have acknowledged this. The United Nations Committee on the Convention of Elimination of All Forms of Discrimination Against Women in its general recommendation has recommended that state parties should act to protect women against violence of any kind, especially that occurring within the family. The phenomenon of domestic violence is widely prevalent but has remained invisible in the public domain. When a woman is subjected to cruelty by her husband or his relatives, it is an offense under Section 498A Indian Penal Code. The civil law does not, however, address this phenomenon in its entirety. It is, therefore, proposed to enact a law keeping in view the rights guaranteed under Articles 14, 15 and 21 of the Constitution to provide for a remedy under the civil law intending to protect the women and girls from being the victims of domestic violence and to prevent the occurrence of domestic violence in the society. Enactment of Protection of Women from Domestic Violence Act 2005. According to a report of the United Nations published in 1980, women constitute half of the world's population, perform nearly 2/3 of work hours, receive 1/10 of the world's income, and own less than 100% of world's property. Prior to 2005, legislations in India have given the women powers in respective fields, but particularly so far as torture, cruelty, and harassment are concerned, the provisions of Section 498A, 304, 305 Indian Penal Code and the Dowry Prohibition Act 1961 are the basic provisions. The provision of Section 498A was enacted to meet the social challenge to save married women from being ill-treated by the husband and his relatives. It punishes demand of property or valuable security from the wife or her relative coupled with cruelty to her. Hence, a person can be prosecuted in respect of both offences, punishable under Section 4 of the Dowry Prohibition Act and Section 498 Indian Penal Code. However, the provision of Section 498A for its applicability predicates a valid and subsisting marriage between the parties. Where there is no valid and subsisting marriage between the parties, no case under Section 498A is made out. The above lapses in the Indian legislations, along with international bounties, compel the Indian government to enact the Protection of Women from Domestic Violence Act 2005 for making restrictive provisions for errant family members, for prohibiting harassment or any violence against women and girls. Features. It covers those women who are or have been in a relationship with the abuser where both parties have lived together in a shared household and are related by consanguinity, marriage, or through a relationship in the nature of marriage or adoption. In addition, relationship with family members living together as joint family is also included. Even those women who are sisters, widows, mothers, single women, or living with the abuser are entitled to legal protection under the proposed legislation. It defines the expression domestic violence to include actual abuse or threat, that is physical, sexual, verbal, emotional, or economic. Harassment by way of unlawful dowry demands to the women or her relatives would also be covered under this definition. It provides for the rights of women to secure housing. It also provides for the right of a woman to reside in her matrimonial home or shared household. This right is secured by a residence order which is passed by the magistrate. It empowers the magistrate to pass protection orders in favor of the aggrieved person to prevent the respondent from aiding or committing an act of domestic violence or any other specified act, entering a workplace or any other place frequented by the aggrieved person, attempting to communicate with her, isolating any assets used by both the parties and causing violence to the aggrieved person, her relative or other who provide her assistance from the domestic violence. It provides for appointment of protection officers and registration of non-governmental organizations as service providers for providing assistance to the aggrieved person with respect to her medical examination, obtaining legal aid, safe shelter, etc. Definition of domestic violence. No longer is domestic violence understood as wife beating alone. The Protection of Women from Domestic Violence Act 2005 has broadened the meaning to include a broad range of acts of omission or commission. According to Section 3 of the Act, any act, omission or commission or conduct of the respondent shall constitute domestic violence in case it harms or injures or endangers the health, safety, life, limb or well-being, whether mental or physical, of the aggrieved person or tends to do so and include abuse and economic abuse, or harasses, harms, injures or endangers the aggrieved person with a view to coerce her or any other person related to her to meet any unlawful demand for any dowry or other property or valuable security, or has the effect of threatening the aggrieved person or any person related to her by any conduct mentioned in Clause A and Clause B, or otherwise injures or causes harm, whether physical or mental, to the aggrieved person. Explanation 1. For the purposes of this section, physical abuse means any act or conduct which is of such a nature as to cause bodily pain, harm or danger to life, limb or health, or impair the health or development of the aggrieved person, and includes assault, criminal intimidation and criminal force. Sexual abuse includes any conduct of a sexual nature that abuses, humiliates, degrades or otherwise violates the dignity of a woman. Verbal and emotional abuse includes insults, ridicule, humiliation, name-calling and insults or ridicule, especially with regard to not having a child or a male child, and repeated threats to cause physical pain to any person whom the aggrieved person is interested. Economic abuse includes deprivation of all or any economic or financial resources to which the aggrieved person is entitled under any law or custom, whether payable under an order of a court or otherwise, or which the aggrieved person requires out of necessity, including necessities for the aggrieved person and her children, if any, stridhan, property, jointly or separately owned by the aggrieved person, payment of rental related to the shared household and maintenance. Disposal of household effect, any alienation of assets, whether movable or immovable, valuables, shares, securities, bonds and the like, or other property in which the aggrieved person has an interest or is entitled to use by virtue of the domestic relationship, or which may be reasonably required by the aggrieved person or her children or her strident or any other property jointly or separately held by the aggrieved person, and prohibition or restriction to continued access to resources or facilities which the aggrieved person is entitled to use or enjoy by virtue of the domestic relationship, including access to the shared household. Explanation 2. For the purpose of determining whether any act, omission, commission or conduct of the respondent constitute domestic violence under this section, the overall facts and circumstances of the case shall be taken into consideration. Kinds of domestic violence. It is a Herculean task, rather impossible, to summarize the kinds of domestic violence faced by the women in India, right from dowry debt to abatement of suicide, cruelty, hurt, grievous hurt, wrongful restraint and wrongful confinement, sexual intercourse during separation, bigamy and adultery are kinds of domestic violence. Passing of abusive remarks, taunting, curtailment of basic needs such as food, clothing and medical assistance in case of sickness, etc. are part and parcel of domestic violence, though these acts of or conducts were not judicially recognized before the coming of this Act 2005. Now, we shall discuss the definition of cruelty prior to the coming of the Protection of Women from Domestic Violence Act 2005 and after the coming of the Act. Cruelty. In India, certain forms of domestic violence have been made offence under the Indian Penal Code, namely Section 498A, which deals with cruelty by a husband or his relatives to a woman. Cruelty in the form of domestic violence may be physical or mental, criminal or civil. However, 4 types of cruelty are considered as an offence under the Indian Penal Code. Intentional conduct which is likely to drive the women to commit suicide. Intentional conduct which is capable of causing injury to the limb, life or health of the women. Forcing women with a view to get some property. Harassment because women or her relative did not give some property. A single act of physical violence and a series of small acts of violence amounts to cruelty. It may be physical or mental. However, constant nagging, false accusation of unchastity, etc. are treated as mental cruelty. The term harassment has not been defined in the statute, but the courts in India have held the following as harassment: forcing women on perverse sexual intercourse, denial of food, forceful confinement of women within the house, repeated physical assault, repeatedly abusing children in presence of their mother, causing mental torture, denying women access to children with a view to cause mental agony. Taunting amounts to harassment, threatening divorce, etc. The term cruelty as defined in explanation appended to section 498A IPC reads as under: cruelty means any willful conduct which is of such a nature as is likely to drive the women to commit suicide or to cause injury or danger to life, limb or health, whether mental or physical, of the women, or harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. These domestic violence were judicially recognized prior to 2005, and the offences given in the Indian Penal Code are not sufficient. For example, if a woman is subjected to cruelty by any person, man or woman, in a family, Section 498A IPC cannot be affected. The provisions of Section 498A IPC for its applicability predicates valid and subsisting marriage between the parties. Where there was no valid and subsisting marriage between the parties, no case under Section 498A IPC is made out. By invoking Section 37 of the Protection of Women from Domestic Violence Act 2005, the central government made rules in the form of the Protection of Women from Domestic Violence Rules 2006, which supplements the Act 2005 for carrying out the provisions of the Act. In the said rules, many forms of domestic violence have been recognized, and the aggrieved person can seek protection order under the Protection of Women from Domestic Violence Act 2005. The offences are given below. Physical violence, for example, beating, slapping, hitting, biting, kicking, punching, pushing, shoving, or causing bodily pain or injury in any other manner. Next is sexual violence, for example, forced sexual intercourse, forcing women to look at pornography or any other option pictures or material, any act of sexual nature to abuse, humiliate or degrade the woman, or which is otherwise violative of women's dignity, or any other unwelcome conduct of sexual nature. Child sexual abuse. Next is verbal and emotional violence. Example, insults, name calling, accusations on the woman's character or conduct, etc. Insults for not having a male child, insults for not bringing dowry, etc. Preventing the woman or a child in her custody from attending school, college or any other educational institution. Preventing the woman from taking up a job. Forcing the woman to leave her job. Preventing the woman or a child in her custody from leaving the house. Preventing the woman from meeting any person in the normal course of events. Forcing the woman to get married when she does not want to marry. Preventing the woman from marrying a person of her own choice. Forcing the woman to marry a particular person of his or their own choice. Threat to commit suicide. Any other verbal or emotional abuse. Last is economic violence. Example, not providing the woman money for maintaining herself or her children, not providing food, clothes, medicines, etc. for the woman or her children, stopping the woman from carrying on her employment, disturbing the woman in carrying on her employment, not allowing the woman to take up an employment, taking away the woman's income from her salary, wages, etc. Not allowing the woman to use her salary, wages, etc. Forcing the woman out of the house she lives in. Stopping the woman from accessing or using any part of the house. Not allowing use of clothes, articles or things of general household use. Not paying rent if staying in a rented accommodation. Enforcement of the Act. The Protection of Women from Domestic Violence Act provides for more effective protection of the rights of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family. According to the Act, any harm, injury to health, safety, life, limb or well-being or any other act or threatening or coercion, etc. by any adult member of the family constitutes domestic violence. Any woman who is or has been in a domestic or family relationship, if she is subjected to any kind of domestic violence, can complain, aggrieve or affected women can complain to the concerned protection officer, who is appointed by the state government under subsection 1 of section 8. Police officer, service provider, an entity registered under subsection 1 of section 10, or magistrate. Aggrieved woman has a right to be informed about the available services and the free legal services from the protection officers, etc. Shelter home and medical facilities can be provided to the aggrieved woman. The proceedings of the complaint can be held in camera. Every aggrieved woman has the right to reside in a shared household. The protection order by the magistrate can be given in favor of the aggrieved woman. The monetary relief can be given to the aggrieved woman to meet expenses or losses. The Act further provides for appointment of protection officers and registration of non-governmental organizations as service providers for providing assistance to the aggrieved person with respect to her medical examination, obtaining legal aid, safe shelter, etc. Conclusion. This Act has been enacted keeping in view the rights guaranteed under Articles 14, 15 and 21 of the Constitution, besides the provisions provided for the offence of dowry death and cruelty in the Indian Penal Code. On the day of coming into force of the Protection of Women from Domestic Violence Act 2005, that is 26 October 2006, the women abuse in domestic sphere was reduced. A survey conducted by Saurashtra Kutch Network on Violence Against Women on 29 October 2006 revealed the data after the Act came into force. The Protection of Women from Domestic Violence Act 2005 is intended to bring social justice to the women who have been discriminated since time immemorial. This is a milestone in achieving the advancement of women to bring social equality, which is one of the objects of the Charter of the United Nations and the Universal Declaration of Human Rights.